Okay, so this is known as land transactions. Okay, as we've always been doing, you should note that land transactions, it has different transactions. So what is most pertinent for you to appreciate how many transactions do we have and how do we treat these transactions? Okay, the very first form of transaction we have is known as a sale transaction. That was your very first topic at the back. Okay, then the second transaction you have is known as transfer stroke registration. What you guys know are commonly known as fraud. It is also a transaction. Okay. Another transaction we have is known as lease. We covered leases. It was a form of a transaction. So we have another transaction known as mortgages. So we are going to deal with the mortgage transaction. So what you should note, this is the simplest and a little bit confusing. So when you are dealing with this transaction, some of the things in our very first classes, we came up with what we call general principles that do apply to all land transactions. And these are known as legal restrictions to land transactions. So when you are reading this, first ask yourself what legal restrictions are in this type of a transaction. We have the general transactions, okay, the general transactional restrictions, and then these, okay, that are specific on that particular type of a transaction. So this transaction of mortgages, basically what we are supposed to deal with, one, what is a mortgage? Okay, wait. Okay, what is a mortgage? Okay, nature of a mortgage, types of mortgages, who can mortgage, a mortgager and those words are so confusing. Okay, then creation of a mortgage, the different ways through which we create a mortgage. Okay, and then rights of a mortgager and rights of a mortgagee. That's where Pastor for the week should put emphasis, because a mortgager, okay, you should understand what we call the law relating to redemption. Okay, what do you understand? At what point can, okay, the mortgagee exercise his or her rights? Okay, do you appreciate what amounts to section 19? What amounts to the default? Section 19 has different notices. Okay, that's the most confusing part. Then also look at what we call the law of tacking. Can two mortgages exist at the same time? So you should also be able to interpret certificates of title where mortgages are registered as encumbrances. That's what at times referred to as first mortgage, second mortgage, and the subsequent. So how would we relate to that? When you are exercising your rights, what things should you look at in circumstances where we have those categories of mortgages? Okay, how should you enforce your rights? We shall look at the law regarding priority, first in time, first in game. Those are mortgages, very brief, like a mini skirt. Okay, and precise. So as it is always our modus operandi, we first analyze the law, then we look at the facts. So make sure you sit somewhere, someone with the Land Act, the Mortgage Act, okay, before you do anything else. Okay. Okay. At least be near the law, eh? Because it really makes life better. Anita, Ninda Gwenna. Not sit there. So let's get our laws. Okay. Let's get our laws. Do you have someone with the constitution? Yes. Okay. So deal with the constitution. Okay. Because we are going to read these laws. After we shall be able to understand. Okay. First and foremost. Okay. That's what are the rights of women?
Right to own land, right to inherit property.
What are the rights of women?
Right to inherit property, rights of women. Right to fair hearing. Right to game education.
Okay, let's zero down to this. So the starting point of this is Article 26. So let's open Article 26. We are reading the laws first. Okay, it's not going to take long. Don't worry. This workshop is small. The smallest in all the workshops of land. Okay. Yes. Okay. So we go on. So let's get our constitution. Okay. Okay. So Article 26 says. And so we can't hear you. Okay. 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 Article 26 is to the effect that every person has a right to own property. Okay. Has a right to own property individually or in association with others. So once you own property, which property are you owning? It is land. So if you are the owner of that land, how are you supposed to deal with? Okay, how are you supposed to deal with your land? Yes. So you have a right to deal with your land the way you want. So you are at liberty to transact with your land the way you deem necessary. So as a result of that, someone who owns land, okay, as per Article 26, how can you deal with your land? So you can sell, you can mortgage, you can lease, you can transfer, whatever the case may be. So at this point, we want to look at one of the ways through which this person can utilize his or her property. Okay. So as per this workshop, it is by way of. So the question is, what is a mortgage? You have the Chattel, is it the Chattel Assets Act? You check if it's on. Okay, it's on there. It's okay. Okay, shall find means of fixing it. We go on. So let's get our mortgage act. Okay. So before you try to understand, okay, you first ask yourself, okay, what is a mortgage? Okay, what is a mortgage? Okay, let's go to section 2. Section 2 of the Mortgage Act, it says, a mortgage includes any charge or lien over land or any estate or interest in land in Uganda for securing payment of an existing or future or contingent debt or other money or money's worth for the performance of an obligation, and includes a second or subsequent mortgage and a third party mortgage and or a subsequent mortgage. Okay? Repeat again. So the catchword in this definition, okay? If you want to understand what is a mortgage basically is a lien you create over your land in favor of someone else, okay, for purposes of obtaining money. Okay, for purposes of obtaining money. Okay, a lien you create on your own land in favor of some other person. Okay, for purposes of obtaining. Either that money is going to be given you right now or in the future. That's why it says, okay, existing, you have it right now, future or contingent debt. So you're either borrowing money now or they are intending to give you money next month. But before they give you money, you first create a mortgage. Okay? So are we together? Okay? So from that, we've seen what is a mortgage. Okay? Then ask yourself, from what, because we've seen it is basically on land, not so? So from what type of land you create a mortgage? Okay? Because we saw in leases, okay? In leases, we create from freehold and mile, not so? But ask yourself, okay, is there a restriction on the type of land within which a mortgage can be created or not? Okay. Let's go to section 3. Section 3 of the mortgage, okay, of the Mortgage Act. It says power to create mortgages. Okay. Any person holding land under any form of tenure, out koma toyongerako. Okay, ebisigadde tujja bisimayo tubyetaagira. Okay, it says any person holding land under any form of tenure. So what does that mean? Whether customary, whether freehold, whether mile, whatever the case may be, you can create a mortgage. So it doesn't discriminate. Okay, all forms of land tenure systems you can. So it is open. Okay, why? Because of the right on property. So this one is very open because so that means someone with customary tenure system shouldn't get money because you own customary land, isn't it land? So by virtue of that, this law has made it open, okay, that you can access a mortgage on any tenure. Okay, so now after that, has the law seen? Yes, you own your land, you want to create a mortgage, which we've seen, okay, and you have any tenure, but ask yourself, has the law restricted you on certain things before? you get this mortgage. Those are what we call legal restrictions to mortgage transactions. Legal restrictions to mortgage transactions. Someone with the Land Act as amended. Go to the law that protects women. They know the law that protects them. Okay? Okay? Let's go to the law that protects women. Okay? In that act, look at section 38A 39 of the Land Act. Okay, because I need to read, let me read, because I need to read it out loud. Yeah? But this guy is also to have it. Okay? Oh, you stay with it. Someone has. What do they know? Okay. When you look at section 38, okay, section 38A, okay, A, capital A, which means it's an amendment. It says, every person shall enjoy security of occupancy on family lands. Okay, that's what we call security of. So here that referring to spouses. So what does that mean? In any transaction, once it amounts to family land, you have to seek consent from the spouse. So that means in all mortgage transactions, okay, in all mortgage transactions, you need what we call a spousal. I have exactly the same matter, but I'm waiting I'm going for cross-examination of the bank manager. But the loan officer who gave out the loan, after knowing that the matter is coming for cross-examination, yesterday it was I was closing the plaintiff's case. You know what happened? The loan officer resigned from work. And that means it's not a competent witness. So we have to amend, they have to get a new witness. I told him, please. So either decide, you give me a consent, judgment, or so what the guy did, so they have told me they are bringing the bank manager. I said, it is okay. You bring. We shall see with school. Because of the spousal consent. Okay? So when you look at this, okay? When you look at this, it is very clear. Okay? It says, it goes ahead to define. Okay? Then when you look at section 39, it says restrictions to transfer of land by family members. Okay? 39 is plain. Okay? It says, no person shall, you listen, no person shall sell, exchange, transfer, pledge, mortgage, or lease any family land. B, enter into any contract of sale, exchange, transfer, pledge, mortgage, lease of family land, or give it away in inter vivos, or enter into any other transaction. Okay? Except with the prior consent of his or her spouse. So that means the first legal restriction we have in mortgage transactions is spousal consent. That's the first restriction. So that means you cannot mortgage that land without consent of your spouse. Yes, thanks. Yes. Titled land. Yes, council. When you read this section, it defines, it gives you a broader appreciation of what amounts to family land. Even if it is titled and you are registered as you as the registered proprietor. If it falls within the meaning of section 38, it is family. So what you need to ask yourself, what amounts family land? Okay. The section says, section 38, subsection 4 says, in this section, family land means on which a family is situated, the ordinary residence, whether it is in your names as you the husband, but provided your family resides there, it is family land. That is the first interpretation. Then B, on which is situated the ordinary residence of the family and from which the family derives sustenance. Okay, you stay on this land, but you have rentals. You collect money from these rentals, you pay school fees, you derive sustenance. We don't care whether it is your name in your names or in your wife's names, provided it falls under this. Okay? We don't care, provided it's where we stay. Registration is not a matter in this. Okay? What we look at basically, the meaning of family land. Then, which is treated as family land in accordance to norms, culture, customs, traditions, or religion of the families. Okay? Burial grounds, it is family. So this thing that I'm saying, that is family. Because under the culture, it is treated as family land. So you don't have any ground whatsoever to mortgage, to sell, to lease, to transfer that land without consent. Okay? They can give you facts where Rashid has his matrimonial home in Kawempe. Okay? However, they have a farm along Nakasongola Road of 250 acres. So Rashid goes and sells that farm without consent of the spouse. The spouse can challenge that transaction. You know why? We have a farm. That farm will have agriculture, crops, okay? Because they will tell you that every weekend, Rashid goes and fetches food from that farm. What does that mean? We derive sustenance. The food is sustenance. So what are natural gamba? That's why men who are land, they hide their properties. Okay? 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 Then another one, okay? When you look at, again, the very section says, ordinary residence means the place where a person resides with some degree of continuity, okay, apart from incidental or temporary absence. And a person is ordinarily a resident in a place when he or she intends to make that place his or her home for an indefinite period. So where you are renting is not family home, because you don't intend to permanently stay in that. So what we are looking at, that degree of continuity. They can tell you that Rashid, you know, there is a case that say that, but that case was challenged, that a mere texting a girl and you tell her, come, we stay together, okay, is sufficient evidence of an intention to permanently stay with that person, and that person is entitled to benefit from your, but that position was challenged. So, but when you read this section, you know, sometimes you may be there, you've worked, you have some command, but you've not yet married officially, okay? So, luck hits you well, you buy some plot of land, you construct your small house there, but you're staying alone. So this girl comes one day, that, yeah, okay, it's not even renting. He has a saucepan. Okay? Okay, is that you see, Islam is already is not renting. At least at 8. Islam has saucepans at home and 2 plates. We are 2. So I'm not going anywhere. She goes back the following day. She comes with a bag with 4 skirts and 4 tops. She leaves them behind. What? What does that show? An intention to stay there with an indefinite period of time. So once she comes and you also accept her to stay there, now it stops to be your personal property. It turns into family because you've shown an intention to permanently reside in that place. Okay? Don't allow her. Well, if she comes with her clothes, tell her story what to be. Don't allow her to leave the clothes behind because it, okay? That's not misguiding. Okay? Then also, we have another meaning of family land. Under the same section, it says, land from which a family derives sustenance means A, land which the family farms. Even if it's not where we stay, it is 1,000 kilometers far away from our home, but we do farming from that land. It amounts to family. Then 2, land which the family treats as their principal place. Okay, that is the home where we stay. Then 3, land which the family freely or voluntarily agrees to be treated as family land. You've bought your land, Ogambieko Hajat. You know Hajat? I bought some land in Matuga. It's 100 by 100. They said, oh, either way, because it's that land is vacant, let me do some rearing of some simple animals there. On going there, she has one rabbit. Farm. So that we are giving her consent. Okay? Giving her consent that it is okay. You can use it. You have freely and voluntarily agreed. So you can't sell that land alone. So the best way, buy your land, keep quiet. Sell it peacefully, come and give her some money. But these ladies are hard. You may be wanting to sell your land, you've seen a brand new car. Now we are going to go mom. Abana bali kola ebyabo. Ate kakati Islamu don't say Rosmanya. Ladies, yeah. Okay, so whenever you're given facts and realize that your facts fall within the meaning of this, it is family. So that implies that that land you require consent. Okay, so let's go to the Mortgage Act now. Okay, but you should take time, read consent and understand consent. Okay, counsel for the week, you're going to challenge a sale. I've not yet seen the mood, but I'm sure you're going to challenge a court sale. You'll be given facts where, because also the mortgagor has to carry on what we call a due diligence before agreeing to enter into the mortgage arrangement with you. They have asked, are you married? And you say, yes. How many wives? You say 2. That means even if this land, none of these wives stays there, but you derive sustenance and you feed them, it amounts to. So that means you need 2 consent forms. So the bank may adamantly refuse to seek consent from Hajat number 1. Why? Hajat is hard like a rock. She will ask for commission if you want to sell that land. So this one says, again, number 3, so Hajat number 2 will give consent. So that transaction will be null and void. So you have to read, and then also they'll give you facts where the woman deliberately, without any justifiable reason whatsoever, refused to give consent. The law allows you to sell that land. Okay, we can waive that issue of consent. When you look at section 39, okay, subsection 5, okay, it says that a consent referred in subsection 1 shall not be unreasonably withheld. These women have unjustifiable reasons. There is a transaction of a mortgage I was carrying on, and the guy had 2 wives. So one of the spouse, this gentleman got him some money, okay? He mortgaged some property at a particular place, and he got consent from 2 wives. This man was given 500 million shillings. So what he did, he first bought for the second wife a brand new car of 100 M. Okay. So number 1, keep quiet. But couldn't complain. So what happens? This man wanted to get another loan. He wanted consent. You know what happened? They told this one, I'm not giving you consent unless we enter into a memorandum of understanding. The money you're getting, I'm taking 10% as my share. You either agree or you don't. Now, the man started making calculations there. He looked at the 10% and said, oh, because he was getting 2 billion. 2 billion. And number 1 wanted 10% of the 2 billion. Imagine. So, she had a justifiable reason when it comes back our normal setting. Okay? But when it comes to the law, it isn't justifiable ground you can base on. 2, because that means she was falling under here. She was unreasonably withholding the consent. So I had to move, okay, under subsection 6. Okay, 39 subsection 6, because it says, where the consent required in subsection 1 is withheld, a person aggrieved with the withholding of the consent may appeal to the land tribunal. Okay, so remember the land tribunal is not there, so just write directly to the registrar. So I wrote the registrar, it registering that. Oh my, the man went and repeated, even the guy knelt down. One, let us make that a joke with women. Okay, so let's go now to the Mortgage Act. Okay, section 5. Section 5 of the Mortgage Act. Okay, it says mortgage of matrimonial home. Mortgage of matrimonial home. Okay, notwithstanding section 39, I want you to, you know the impact of notwithstanding. Okay, not yes, that we know it is there. Okay, we say it also applies, but we also need this for this particular purpose. Okay, saying that notwithstanding section 39 of the Land Act, the mortgage, no, we are reading the RTA section 5. Okay, sorry, the Mortgage Act. Okay, it says, notwithstanding section 39 of the Land Act, a mortgage of a matrimonial home, including mortgage on customary land of a matrimonial home, is valid if any document or form used in applying for the mortgage is signed by, or there is evidence from the document that it has been assented to by the mortgagor and the spouse or spouses of the mortgagor living in that matrimonial home. Okay, so spouse or spouses, even Muslims are catered for. Okay, so what does that mean? If you, the law says you can also mortgage matrimonial home. Okay, the law is okay. We can mortgage our matrimonial home provided we want money. Okay, so what all I need is Hajati's consent. It is sufficient. Okay, so that means when you read the section, it uses the word shall. That means it is mandatory. Okay, it is mandatory. Okay. Then when you go on, it says that any document, okay, B, any document or form used to grant the mortgage is signed by, or there is evidence it has been assented to by the mortgagor and the spouse or spouses of the mortgagor living in the matrimonial. So you should have evidence. Okay. Then for purposes of subsection 1, okay, it says an intending mortgagee. The mortgagee, we shall get back understand mortgagee. Okay, we are just still looking at what we call legal restrictions. So the basic legal restriction is, okay, spousal consent. Okay, so when you look at section 5 subsection 2, it says the intending mortgagee here literally is the bank. Okay, the intending mortgagee shall take reasonable steps to ascertain whether an intending mortgagor is married and whether or not the property to be mortgaged is matrimonial home. It is not my obligation, me the person coming to get the loan. It is your obligation as the bank. Ascertain whether Kakaire is married. Okay? Me, have ever gone with someone to get a loan. I was escorting him. No, banks are lazy. This guy said, I'm not married. They said, okay. The guy was married. Unfortunately enough, the guy paid the loan. Yes. Okay. My apologies. Okay. So when you look at this, so these are the details you should put into consideration. Okay. Because you as counsel for the week, chances are high these mistakes you're seeing here are the mistakes that are going to be in the workshop. The bank will fail to take on its obligations. Okay. Then B, an intending mortgagor shall make full disclosure of the intent to the intending mortgagee as to his or her marital status and whether or not the property to be mortgaged comprises of matrimonial. So they're also giving you, the person who wants to get a loan, an obligation to ensure you disclose. That's why we have section 4, duty to disclosure of information. So when you come to the bank, please don't lie, though you always lie. Okay? That's the law. Once we find out that you neglected disclosing to the bank, okay? Because what we want here, negligence, counsel for the week, mark that, negligence, either dropping your client or putting your client in trouble. Negligence, okay? Then, section, okay, subsection 3, section 5, subsection 3, the mortgagee shall be deemed to have discharged the duty under subsection 2 if the mortgagee obtains marriage certificate issued in accordance with the laws of Uganda, and in the absence of it, a statutory declaration from the spouses or spouses of the mortgagor. When is this case coming down? I want to cross-examine this guy. Okay? You see? So, they are telling you that the bank, because you may go in Oros, they tell you that you are the legal office of Barclays Bank. Okay? Rashid intends to get a loan facility. Advise the bank manager on the documents he or she should find on the file. Okay? Now you start asking yourself, okay, so how do they prove marriage? So that means the bank has to obtain proof of either you have a marriage certificate or you have a statutory declaration from the spouse. Because we have people who gotten married customarily and they never registered their marriages. And failure to register customary marriage does not invalidate the marriage. So as a result of that, we go for a statutory declaration. But you will find that they'll give you particulars on that file of the bank when it does not include the declaration or the marriage certificate. So that means you are doomed, basically. Okay? Yes? Yes.
There's a system whereby you are divorced. Maybe you separated for 2 or 3 years.
Yes. Okay. So now, separation doesn't invalidate marriage. Okay.
Now, everybody thinking that we are married. I mean, we are married.
Yes.
But in the association, we are not divorced.
Let's proceed. Okay. No, it's like this. There is a proof of a marriage certificate that you are married, but you separated.
We are not together.
You're not together, but you are not divorced. So, so under such circumstances, you are married.
Also, you say
Yes.
that the divorce proceedings are ongoing,
Okay.
and then you mortgage issue to the command. So you say, remember the process for divorce.
Yes.
That is still
You're still married.
I have this someone who are not there.
Yes. That is the law. Okay. No. Let's get back. Okay. You know the procedure of divorce. Okay. Even where court has made what we call a decree, within those 6 months, you are still married. Okay, you are married, so that means okay, so we go on. Okay, so you see, you are married, whether the divorce petition is ongoing, provided you don't have judgment yet, you are married. Okay? You are married. Okay, so let's go on. Okay, let's go on. Okay, so you've seen, so the duty of finding out the issue of marriage is paramount. So what does this mean? Okay, these legal restrictions are different. We have a legal restriction on family land and a legal restriction on matrimonial. So they are two. Okay, mortgaging family land and mortgaging matrimonial, but the law is so harsh on matrimonial property because that means either kuba mukyala oba musajja ono omuleke ng'akaaba. Okay, are we together? So now we've looked at the legal, but I want you to take time, read section 6 Because the issue of consent in matrimonial property is even where you have 3 spouses or 4. Independent advocate. Listen. Okay, that is section 6. Because section 6, okay, section 6, okay, subsection 1, okay, and yes, subsection 1, paragraph 2, it says, okay, the mortgagee has, okay, in writing advised the applicant, okay, for the mortgage that he or she should ensure that his or her spouses receive independent advice on terms and conditions of the mortgage which is being applied for. So what does this mean? The bank has to write to you and they tell you the rules governing getting mortgages here. You have to advise the spouses independently. Get your independent lawyer and get an independent lawyer for your wife. You advise them. So if we don't have that evidence that you didn't write to the mortgagor, that's what I'm doing in that case. Okay? Because the bank is in breach of these obligations. I'm telling them, give me consent, manager again. Mugamba nkusasira naye oganye. Okay? So you see the issue of consent. So basically what you should know, the mood, okay, is likely to come from that area. Whoever is cancelled for that week. Okay? So now we've looked at the legal restrictions. Now ask yourself, okay? Ask yourself. We've seen, okay, what is a mortgage? And so we've seen who can create a mortgage. Okay, we've seen from what land. Okay, we've seen the legal restrictions. Now we want to see, okay, we want to see how we create a mortgage. And the types. Should we first look at the types or look at the how? The how. How do we create a mortgage?
The types.
Okay. 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 So let's go to the how. Okay. Let's go to the how. Let's go back to section 5 in the first place. Yes. Council for the week, full of some regulations, line by line. Council for the week, line by line. Okuva wekatandikira paka wekakoma, line by line, before closure of business. Okay. Katono, but kekakola mood. Okay. So let's read section 5. Okay. It says, okay. Oh, sorry, section 3. Okay. Section 3 says that a person holding land under any form of tenure may, by an instrument, okay, may, by an instrument in a prescribed form, mortgage his or her interest in the land or part of it to secure. So what I'm interested in, because this section 3 gives us the how. Okay, it says a person holding land under any form of land tenure may buy an instrument in the prescribed form mortgage. So what does this mean? Okay, it is by way of a mortgage. Okay, by way of a mortgage deed. But this mortgage deed has a specified format. So ask yourself, where is the format of this instrument they're talking about? Okay, where is it? Yes, yes, where is it? Yes, let's look at regulation 17 of the mortgage regulations. Regulation 17 of the mortgage regulation. Okay, it says the mortgage instrument shall be in form 1 of the second schedule. So you open the second schedule. Okay, it has the instrument we are referring to. Okay, kati gogena kuba mortgage deed yo. Okay, mutima mulungi. Okay, you wait, you're going to see it. Okay, you're going to see it. Hey. Okay, so when you look at form 1, okay, you listen. It says form 1, mortgage instrument, the Republic of Uganda, in the matter of the Mortgage Act and in the matter of the mortgage regulations of 2012, mortgage instrument. So depending on the type of land you are mortgaging, it has freehold, if it is freehold, leasehold, mile, or customary. So you choose one, depending on the facts you have been given. You choose one. Then you come here, I, okay, Narubwama, being the registered proprietor of land described above, in consideration of a sum of shillings, the money they are giving you, okay? This day, brings to me by, you put the bank, okay? In this mortgage deed, I agree with the mortgagee as follows. Then you put, okay, what you've agreed upon. 1, to pay the mortgage of his or her transferees and the principal sum. You indicate whatever you have agreed upon. So you're going to find a legend who is going to draft a mortgage deed. Gainer pages, term. But the law is clear. You know why they gave it a format? The reason why they gave it a format, even we have, when you look at the law of banking, because after this, you create what we call a loan agreement. The loan agreement shouldn't exceed 4 pages. Maximum 4 pages of A4 size. That is the law. Why? Because when you write a lot, you tend to confuse the mortgagor and end up signing what they don't understand. Kati gogenda jikola mu kitabo just the mortgage or jikola nga 3 pages. But in the act is only one like this. It's only 1 page. So that means if you are writing in pen, it should be around 1.5 or 2. You get it? Okay? So we've seen the how.
Maybe obwedde okuba nga ndi mu kibiina kati.
Okay, we go on. So we've seen the how. Now we want to look at what are the different types of mortgages. That was my first question from Council Banenya the Great in my orals. Okay, but the way they asked this question, they told me, Rashid, assume you are a legal officer of this gentleman here. Okay, he gives you the following set of facts that he's jobless as of now. Okay, he has no source of income whatsoever, and he has never bought any property in Kampala or anywhere, but he wishes to access some money from the bank. Give him 3 circumstances under which he can access the same money. So literally, they're asking me types, okay, of mortgages. Number one, the following, okay. So the first one is known as a direct mortgage. A direct mortgage, okay. A direct mortgage, okay. A direct mortgage, this is a mortgage that is granted to the owner of the land, him or herself. Okay? A direct mortgage is a mortgage that is granted by the owner of the property. Okay? He is the registered proprietor. He's the one getting the loan from the bank. So the mortgage will be between him and the bank. Even the loan agreement will be between him and the bank. That's what we call a direct mortgage. Okay? You are the owner of the security. You are the direct beneficiary of that. That's what we call direct mortgage.
Granted to or by the.
Okay? It is granted to the owner of land. It is provided for under which section? Okay? We shall get there first way, because when you understand mortgage and mortgagee, those words will not confuse you. Okay? Imagine they ask that thing in orals. Differentiate between a mortgagee and, because we are used on a trustee. Okay? Lender, borrower. Okay? Guarantor, guarantee. But when it comes to mortgagee, it is the opposite of what we always know. So for when you get a differentiate, when you hear the wording, you may think that a mortgagee is the bank. You get it? But a mortgagee is the bank. You get it? It is a bit confusing, but we shall get there. Okay? Okay? We are going to get there. We shall go to those definitions. Don't worry. Okay? So are we together? We go on. So let's read section 3. Section 3 is the law that provides for a direct mortgage. Every time you read it. Section 3 of the Mortgage Act provides for direct mortgage. Okay? Did you guys read the case of Frederick Zavas Orient Bank? It is here. It is back again in mortgages. Whether you like it or not, you want to escape that case. Even in the third term in corporate and commercial, it is mandatory in banking. Kuva first term buli course ndi alimu credit zaabwe family land corporate naye gwe wagana ogisoma. Even today it is back in mortgages, but I assure you era ogenda gana ogisoma ne mu third term edde mu corporate and commercial mu banking era ogana ogisoma. So let's go on. Okay, so when you read section 3, it says that a person holding, you hear the provision, it is direct. Okay, a person holding land under any form of land anyone may, by an instrument in the prescribed form, mortgage his or her directly. You get it? That's why it's called a direct mortgage. Okay, that's the first one under that law. Okay. The second type of mortgages is known as a mortgage by powers of. It's provided for in the case of Frederick Zavas versus Orient Bank. Hey, you're joking with that case. Okay. So the second type of mortgages is a mortgage with powers. Okay. Someone with the RTA. You know the law that talks about powers. Okay, in the RTA. Okay. Which section is that? Yes? Which section is that? The RTA. Okay? Which section in the RTA talks about powers? Yes? Okay, it is 100. Okay, powers of attorney and attestation of instruments. Okay, so when you look at that provision, it talks about, so any proprietor of land can give you powers to get a loan over his or her. You get it? So before we read the provision, when you look at the facts of Frederick Zawe, if you read the case, what happened? He had to pay someone, okay, but he didn't have money immediately, okay. So he went to the bank to get some advance, but he didn't have security. So he talked to a colleague, and this colleague had security. So this colleague gave him powers, but they were not special powers. They were okay. So you have to differentiate. We have what we call restrictive, special, and open powers. Restrictive, you are restricted on only that thing. Then limited, they are limited on a particular. Then open, you are free to do anything you want. So now, these powers, okay, these powers that were given to this gentleman, they were limited, not inclusive of mortgaging. Okay, they were limited. They gave him power over the title, okay, to utilize it in the powers. For him, what he did, he mortgaged and got a money. So the bank did not do what we call due diligence, just advanced money using the powers. Okay, so they relied on that section 146 of the RTA. Okay, so the powers were defective. Okay, one, the powers were not attested to in the right way. So the bank didn't carry out due diligence. So they went on and advanced money to Frederick Zawe, basing on the powers of. Why? By that time, banks were not so vigilant. When you look at your reading list, look at the year of that case of Frederick Zawe. Okay? It is of 2006. Okay? It's case number 6. Okay? It is 2006. You're going to see how this case changed, and it's the case that almost led to amendment of this act in 2009. Because they had to cure that loophole. Okay? So what? Because if you look at also the RTA, after that saga, attestation was incorporated. They had to describe how an instrument relating to land should be attested to. Because these powers, the guy just signed his signature. He didn't include his name. Okay? The designation donor and donee. The guy just signed, just scrubbed. And he was like, hey. So when he was arguing in court, he argued that the powers were defective. Bank and Ajikuba, Yamualoni, Nemuani costs. Okay?
But if you read that case,
he was a bright man.
If you read that case,
Okay?
If you read that case, it's not aggressive as you say.
Okay?
It's not. There's nothing interesting. But the way you talk about
no, you see, yes.
You read it, you
okay? No, when you look at this case, okay, it has 3 cases. Okay, it has a high court case, it has a court of appeal, and a Supreme Court. So if you want to understand the entire story, or you know some cases is, but 90% of you always use the Supreme Court case. Because what happens in the High Court, Zawe won. Then the bank appealed in Court of Appeal. Zawe never was there. Never appealing in Court of Supreme Court. Okay? It's a Supreme Court case.
But we are going to go by that.
Okay. So you get it. So Meya High Court we are so kuangulira. Omuliro gwaliwo mungi. But okay. So you get it. You take a benefit. So yes, Frederick is our one again. Okay. So when you look at the sections we've been looking at, okay. So when you look at section 146, 147, and 148, they are very clear when you are dealing with a transaction in powers of. But now, after the Frederick Zabo saga, banks were awakened. They realized their mistakes. So they stopped carrying on mortgages by way of powers of. So you can't go in any bank with powers and you get a mortgage now. Okay, yes. So after that case, there is another case that came into place and it changed. Yes, because you'll meet it in orals. Okay. So, but after the Frederick Zabo
Excuse me, counsel.
Yes.
Sorry, mortgage by power of what?
It's by powers of attorney. Okay.
Thank you so much, sir.
Okay, welcome. Okay, so we have another case, okay, that brought in the new type of mortgages. So the third type of a mortgage is known as a third-party mortgage. A third-party mortgage. Okay, a third-party mortgage. Where's this case? Yes. Huh? Yes. 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 Okay, so we go on. So ask yourself, what is a third party mortgage? Okay, what is a third party mortgage? Let's come to, when you look at the definition of a mortgage itself, it says includes the third party mortgage. Okay, but we want to know, you hear the wording third party, that means this mortgage has three parties somewhere. Okay, that was the IA your colleagues did last year. Because it has a guarantor, it has a third party, it was trouble. Okay, so let's go on. Okay, does the Mortgage Act define a third party mortgage? So let's go to the definition of a third party mortgage under section 2. Counsel for the week, don't rest, yeah? Okay, it says third party mortgage means a mortgage. Listen, if you understood a direct mortgage, now a direct mortgage is an opposite of a third party mortgage. But the challenge is in the way of creating it, the documents that we deal with. Okay, it says a third party mortgage means a mortgage which is created or subsists to secure the payment of an existing or future or a contingent debt or other money or monies worth for fulfillment of a condition by a person who is not a mortgagor, whether or not in common with the mortgagor. A person who is not a mortgagor, okay? So let's take this example. He's the bank, okay? She's the landlord in Kabugo. She has a title, okay? She has just come from Chamliwa. Okay, she wants to get money to start up a mobile money kiosk around LDC. Okay, she approaches bank Jeff Limited to access a loan. They ask her, do you have security? She says no. Okay, but she wants to get money. So she will approach the sister who is the landlord in Kagugube with a title. Namgama, sister, I want to get some money from Jeff Bank Limited, but they have told me I should take security. Can you help me with your title? Under this, she will not give her powers up. You get it? They will go together to the bank. Okay? So what happens? She's a third party now. Okay? Jeff Bank Limited will enter into what we call a loan agreement with her. Loan agreement. Okay? A loan agreement. So that Jeff Bank Limited is advancing money to her. Okay? And she will sign on the loan agreement as the guarantor of the owner of the land. Then after signing on the loan agreement, Jeff Bank Limited will make a mortgage deed with her. She's the mortgager. Okay? Money, okay? You get it? Money is given to another party who is not a mortgager. So a mortgager is someone who gives in security to the bank to get money. So she has mortgaged her land in her favor. So money is given to a third party. Okay? So what does that mean? You are a guarantor on this loan agreement. So that means it is your obligation to always come and tell her, okay? You get it? So that's the challenge they had in powers, because in powers of attorney, they could not, it was very hard, the donor to come and tell this person to pay, because the donor could not witness the loan agreement. So the bank said no. Okay? Yes, Council. It is like this. The relationship between the bank and the owner of the land is what we call mortgagee relationship. The relationship between the bank and her is what we call the lender-borrower relationship. The relationship between her and her is what we call guarantee relationship. Okay? Hey. You get it? Okay? It's like this, okay? In the third party mortgage, twin arm relationship says that the first one, it's like this, is Jeff Bank Uganda Limited. She's the registered proprietor of land comprised in block this land at Kagugube. She's the sister who wants to get money from Chanamkaka. She has nothing, okay? Only her heart and her life. But she thinks she will make it in Kampala. So she wants money, okay? So she approaches Jeff Bank Uganda Limited that, you know what? Give me some money. Then Jeff tells her, do you have security? She says no. So they tell her, I can't give you money. Okay? Then she comes back to the sister Mugambe. I have a bank that is intending to give me money, but they want security. Can you help me with your title? So under here, she's not going to give her powers. Okay? They will go together. Jeff Bank Limited. Okay? So she will tell Jeff Bank Limited, I have security. Okay? So she's the security. Not, okay, you get it? So she becomes the security. So what Jeff will do, okay? He will enter into a loan agreement with the third party from Chanamkaka. Okay? That on that agreement, this landlady of Kagugube will sign as a guarantor. Okay? You get it? Okay? Then after, Jeff Bank Limited is going to give money to Hajat from China because of the lender-borrower relationship. Then after, Jeff will enter into another relationship with the landlord known as the mortgagee relationship. She will mortgage her land in favor of her sister. You get it? Oh. Okay, so what does that mean? We have a relationship between the landlord and Jeff, which is known as mortgagee. She mortgages her property. That is the technique in third-party mortgages. You mortgage your property to secure money for another person. Have you ever borrowed money for someone? That's how it looks like.
So how is the
real mortgage deed we have in the act? The third part type of mortgage. In the mortgage deed? No. That's why we have a lender borrower. Evera loan agreement atute sente neta ina musingo yono.
But the wording says, because I think the wording is,
let's read the definition again. It says, okay, a third-party mortgage means a mortgage which is created or subsists to secure payment of an existing or future contingent debt or other money or money's worth, or the fulfillment of a condition by a person who is not a mortgagor. Okay, the person who's getting that debt is not a mortgagor, is the third party. Okay, so that means we should have a mortgagee, we should have the borrower lender relationship, and then we have guarantor guarantee relationship. Easy. Okay, 3 relationships. Okay, you should mark that.
3 relationships.
Okay, so counsel for the week. Also, the OIA may come from that. How? Okay, at what point will the guarantor be exonerated? Okay, at what point will the guarantor be exonerated? So we know kubanga wakasomye bulungi ne katulayo. Okay, so you see that, so we have a case that establishes third-party mortgages is not seeing it, but it's I'm very sure it should be there. The direct case, but I'm trying to locate the case for you guys. Hold on a bit. Yes. Okay. So look at the year of that case of Guma Paulino, number 34. Okay. It is 2008. Okay. The Mortgage Act is of which year? Now you see how I told you that the case of Frederick Zabo made a greater impact. So when Guma Paulino went to get a loan from the bank said no. Frederick Zabo, so they gave them another format of doing it, which was the third party. But as a result of that, these guys defaulted. So the bank wanted to proceed against the guarantor. So they had to go to court to determine whether the guarantor was liable or not. Because the guarantor had a mortgagee relationship with the bank. So the mortgagor had to pay by all means. Okay? So that means the third party was exonerated. You get it? So the contention was to differentiate the relationships. So when they went to court in 2008, after making that judgment, the recommendation was to amend the Mortgage Act in 2009. and they included what we call third-party mortgages. So you saw how the amendment came into place. That's the reason why this act was amended in 2009. Bononya mo act yenkadde kemuli third party. It was included in 2009 after the case of Guma Pauline. So we've seen the types of mortgages. Okay, so now, okay, we have to start break our fasting. Okay. Okay, so how swift can we do it? Because we are ending, we would have left this place by 7:30 and we go home. Okay.
We need to break our fast and pray.
No, you give it. I still have to pray.
So let's first break the fasting. Okay. And you pray. We shall get back in shall we dance by 7:20?
Yes. Let's start.
Okay, so we are pausing this session. We break our fasting, we get back, we are left with like 5 sections. Okay, and then we read the workshop and we call it.